Well, well, good morning. Welcome to Coffee with Dr. Childress. Uh, Crumpets in coffee, except this morning it's Danish pastry and coffee um, in honor of Denmark for some reason. So today I want to talk about cross-examining mental health testimony. Now, I'm a clinical psychologist, not an attorney, and the world of courts is the world of attorneys. And so I'm going to be giving you information not about how to exactly cross examine them in your questioning or um, in the testimony, but more about the psychology foundations or the vulnerabilities as psychologists that these forensic psychologists have. In addition, so I'm not an attorney, and so attorneys are going to ask the questions within the context of the courtroom, the environment of the courtroom, the legal strategies they have, as well as the rules for asking questions in the courtroom. In addition, I'm not a forensic psychologist, and I'll be talking specifically about um, cross examining that subspecialty domain, forensic psychologist. I'm a clinical psychologist. I do diagnosis and treatment, I don't do custody. Forensic psychologists are a subspecialty practice. All psychologists are licensed as clinical psychologists, and then some specialize in forensic psychology, which is child custody evaluations primarily. And so I'll be talking about how to examine or look at the vulnerabilities of these forensic custody evaluations, but I'll be speaking from a clinical psychology aspect, which is diagnosis and treatment, ethical standards, professional standards of practice, things like that. And again, all psychologists are licensed as clinical psychologists. So the first thing to understand, um, well, let me start here. There's several lines of questions I'm going to go through um, or discuss this morning. And in cross examining mental health testimony, I suggest you think in terms of lines of questions rather than individual questions, that the lines set up with some basic information, then they proceed on a very linear path. And I recommend on that linear path, if you can, just yes or no questions. Don't let them expound out into words and words. Keep them on a linear path of yes no questions and take them right to the end. And there's concluding issues or questions to ask. And so it's a very linear path. And the reason for that is that the forensic psychologists have a thought disorder, thought problem. Let's put it that. May not be quite a disorder, but it's pretty close. It's a problem in linear logical thinking. It's a frontal lobe executive function, and they don't have it. Um, they start with the conclusion as fixed, and then but don't follow the evidence to that conclusion. So, if with thought disorder type of thinking, what you do is you stay on a very linear path with them, and there will come a point where it doesn't make sense. They start to contradict themselves, and things kind of fall apart for them. So that's what the lines of questions are designed to do. And in my consultation with clients, um, I've often brought these forensic psychology evaluations to help sort of redirect evaluations that have gone astray. And as part of that, once I provide my analysis and summary report for the client, I can also work with the attorney in helping to come up with these sorts of vulnerabilities and lines of questions. And so that's the approach, is just to have an organized set of questions to go down. And I'm going to discuss today diagnosis, the issue of diagnosis, and a set of questions um, or a set of domains that you'd want to move through with the diagnostic line. In addition, standard 2.04 of the ethics code, that's where they're most vulnerable. And that will be your entry point to undermining their credibility or impeaching their testimony. And 2.04, which is Bases for Scientific and Professional Judgments, links to standard 9.01, and that's bases for assessment. And that's what they did, a basis for assessment. And the final piece that you will reach on 9.01, basis of assessment, is that their opinions, as contained in their recommendations, report, diagnostic and or evaluative statements, including their forensic testimony, is not based on information and techniques sufficient to substantiate their findings. And so that's going to be the critical standard you land on, because you want to impeach their testimony. You want to redirect away from where their conclusions and recommendations kind of went haywire. And so you want to demonstrate that their opinions and forensic testimony and evaluative statements, even if they're not diagnostic, are not based on information and techniques sufficient to substantiate their findings. And so the earlier questions will be to set that up, and then you'll land on that one. You can also land on boundaries of competence at standard 2.01. So you actually have three ethical standards in there. Boundaries of competence, you would look at their vita, not their report. So the other two, 2.04 and 9.01, are kind of a pair. That they violated 2.04, which means they violated 9.01. And if you look at 9.01, the bases for assessment, it cites back to 2.04. So there's a nice little kind of tight circle on those two. But I'm going to start with just some terminology just to kind of get organized to our approach or to the approach. And listen to these two sentences. These two sentences mean exactly the same thing. We must first diagnose what the pathology is before we know how to treat it. We must first identify what the problem is before we know how to fix it. So, diagnose means identify, pathology means problem, treatment means fix it. So you can use those words interchangeably in your questioning, and to great purpose, I think, because they get illogical. The psychologists, when you start to talk about diagnosis or treatment, they start to say, I don't diagnose it. You don't identify what the problem is? Well, I do identify. Well, then you diagnosed what? No, I did. And so they'll start to wrap themselves up when you start to switch around those terms on them. So another, I think, important quality to cross-examining mental health testimony is the tempo you use. So there's an opening sort of domain where they're going to be very relaxed. Typically, forensic psychologists tend to be a little arrogant, little puffy, little grandiose. And so they'll come in expecting to just sort of pontificate about their opinions and not really have them challenged very much. And so in that relaxed state, that's when you want to get a lot of statements from them that are vulnerable for them, but they don't realize it. And so that's a nice period to sort of ease them into the questioning. Because once you start asking about ethical standards or diagnosis and you start putting them on the spot, their anxiety is going to rocket to the ceiling. Psychologists are risk averse. We don't like risk. We run from it. And holy cow, the courts are so risky. Our wording has to be so precise in our testimony, and we got a court reporter, and we're under oath, and we got a cross-examining attorney who wants to discredit us. It's a very dangerous place. And if we say anything wrong, somebody can go after our license after the testimony. So it's a very dangerous place for us. And with psychologists, we will always, almost always, take the less risky answer. So if you use the word never or always in a sentence, we're likely to say no, no matter what the content. So has this never happened? Well, no, it's sometimes maybe. So you always do that? Well, no, not always. Sometimes. We'll go to the middle. And if you put the word possible in there, you're likely to get a yes all the time, independent of content. Is it possible there was child abuse? Well, yes, it's possible. Okay, so that's in the early part, or whenever they get kind of locked up in a knot and you're getting some resistance. Is it possible that? Okay. So one of the things that I recommend that I work with when I work with attorneys is on the tempo of the questions. That first phase is sort of getting their exposure, and you want them to relax into exposing their vulnerabilities. And then once you get the middle part, and you see them kind of alert, and now they are watching their answers very carefully, and they're doing a risk assessment on every answer that they give. What's the dangerous answer? What's all the possible implications of this answer? And they're just stressed. They're stressed and doing risk. And that's exactly where you want them to be. And you want to keep them in that stressed risk evaluation place for every single sentence, for a question. And because the questions are lines, they're not coming in from different directions. They realize you're going for something. There's something here that's dangerous for them, but they can't quite see it yet. And so they're going, ooh. And that's going to take brain chemicals, stress chemicals. It's going to be stressing the risk assessment for each question. And with attorneys, I recommend that you push each line of questions, just move them all together at the same time, bouncing back and forth between them. Because you set a context such as a diagnosis, and you get them into a risky place on that line, and then you switch over to standard 2.04, and you start talking about family systems therapy, and they're going, then you switch to attachment. Oh my God, now they're having to think about attachment. Then you switch over to, boundaries of competence. Then you switch back to diagnosis, and you keep them all because they have to keep switching context then, and all the relevant information to do their risk assessment for each answer they give. They're going to be exhausted by the time they reach the end of these lines of questions. And that's exactly the state you want them in. You want them exhausted. Their risk assessment is exhausted from bouncing around, because it's those final questions that are the most dangerous. And by the time they reach that point, they realize they're in trouble, and you may just get them giving up on stuff and not doing the risk assessments anymore. And that's kind of the place that I'm shooting for, to where those final questions, they kind of surrender to the previous exposure and just surrender to whatever the questions are. It's so much easier to get a board complaint or malpractice lawsuit if they've admitted in the testimony that there's been ethical violations and practice violations. So let's start with the forensic psychologist here. I'm going to run down 3 lines today. The diagnosis line, and I'm going to do them sort of generally, not specifically, the diagnosis line, and explain to you where they're vulnerable on that, immensely vulnerable. Then 2.04, bases for scientific and professional judgments, and that's your entry on undermining and discrediting their assessment. And then that links over to 9.01. Now, when you introduce these lines of questions, um, now again, I'm not an attorney, so I don't do the courtroom stuff, but as a psychologist, I would recommend that you start with the definitions. Get them to define things because that's going to put them in the noose. So, example, if you're going to start questioning about standard 2.04, which is bases of scientific and professional judgments, and you say they have psychologists have to use the established scientific and professional knowledge of the discipline. So you say, doctor, is family systems therapy the established scientific and professional knowledge of the discipline? Would that be something you are required to apply? Yes. Would attachment theory and attachment pathology, would that be among the established? Yes. Here's the situation too. If the psychologist ever starts to jerk you around and try to give you dance funny answers, don't fight with them. Just expose that. Expose that they are dancing around. Expose it for the judge. Judge sees what they're doing. They're not answering the question. So then once you get it fully exposed that they are being evasive, just move on to the next thing. They basically answer the question. So get them to say, like for family systems, so is that part of the scientific knowledge of the discipline? And then you say, here's a diagram by Minucci. Can you explain this diagram to me? What do those three lines mean? What are that little opening in between the parent, and the child, and the mother and the father in that diagram, or the mother and the child in that diagram? What do those mean? And get them to explain it. What's a cross-generational coalition, doctor? And so you start by getting them as if they knew what they were talking about. So that's an entry into things. That's my recommendation, is get them, would you read standard 2.04 and 9.01? Would you read this standard, 2.04? Do you agree with that standard? Do you agree with what it's saying? Do you follow that standard? And standard 9.01, do you agree with that standard? Do you follow that standard? I noticed standard 9.01 cites back to 2.04. Why does it do that? Why is standard 2.04 important to apply in your assessment? And so you haven't asked them about the fact that they didn't do any of this yet. You're getting them to set up your case for you, just as they're opening. And at that stage, when you're asking them these sort of open questions and you're into that opening period, you can give them more latitude to talk about things because they're talking about things that you're controlling. Once you hit the lines of questions, I'd keep them on yes and no's. Don't let them go out. And that has to do with that thought disorder thing again. They're going to want to move out to what's called associational thinking and start to pontificate about all these vague, soft stuff. You want to keep them down to yes or no because you're looking at what their professional obligations were in that situation and that they did not fulfill them, and particularly going to be kind of coming in on competence, that they weren't competent to do a lot of the assessment. And so keeping them down to yes, no questions once you hit the lines of questions. So typically with an ethical standard, I'd say, read the standard. Do you agree with that standard? Of course, they're going to say yes. Do you follow that standard? Of course, they're going to say yes. You can ask them, why is that standard important? Why is it important to apply the established scientific knowledge of the discipline? So now, with the diagnostic line, let's start there. So The forensic psychologists separated out from clinical psychologists as a subspecialty about 40 years ago, 1980s, and they uh, assert that they don't diagnose pathology. They do something different than clinical psychologists. Us clinical people, we diagnose and treat pathology. They do something different. Uh, and they like to say they don't diagnose pathology. They, they say one of two things. Either it's not my role to diagnose pathology, I'm a custody evaluator, I'm doing something different, or um, that they don't like to pathologize people. They'll say that I don't like to pathologize people. So in the early part of your questioning on the diagnosis line, when they're still pontificating and telling you stuff, if you can get them to say that on the stand, that's excellent. So I noticed you didn't have a diagnosis listed in your forensic evaluation. Why is that? Well, I don't diagnose pathology. It's not my role, and I don't like to pathologize parents and people in families. Okay, so you don't diagnose the pathology. So if a parent had schizophrenia, would you diagnose that and tell the court, or would you withhold that information from the court? Now, personally, as a psychologist, again, I'm not an attorney, but when I would frame that question, I would use withhold the information from the court because that's what they're doing. This is the diagnostic information, whether the parent has schizophrenia, is directly relevant to the situation. The court should know if one parent has schizophrenia. And to withhold that diagnostic information from the court does not allow the court to make its decisions. And that's the thought disorder on this one of many. On this one, with the forensic psychologist, is they've even got a standard where they say we don't like diagnostic labels because they are more prejudicial than probative, or often are more prejudicial than probative. That's not our role as psychologists to decide what evidence has more probative or truthful or beneficial value versus prejudicial value. Those are legal issues for the courts to argue about. Our role is just to provide the evidence, which is the diagnosis. So we're going to expose that little thought disorder with the forensic psychologist here. So you say, you don't diagnose. What about schizophrenia? If there was schizophrenia present in a parent, would you tell the court that, or would you withhold that diagnosis? They're likely to say, "Oh no, something like schizophrenia." I would tell the court. They're just going down the rabbit hole here. If they don't, if they say no, wouldn't tell the court if there was schizophrenia. That's going to be a problem for them. So when they say yes, something that severe, something like that, you go, oh, so you kind of pick and choose which diagnoses you tell the court and which ones you don't. Well, I think and then they'll kind of start to flutter around a bit. And so, what's your criteria then? That which diagnoses you reveal to the court and which you withhold? And they'll flutter around some more. Then get to the real point. What about child abuse, doctor? If there was child abuse in the family, would you tell the court about that, or would you withhold that diagnosis too? Oh no, I would tell the court if there was child abuse. Okay, what are the four DSM-5 diagnoses of child abuse? Physical abuse, sexual abuse, neglect, and psychological abuse. So it's four of them. Okay. Now here's where they're in trouble. Okay. So then you've got them to say, yes, they would tell the court about child abuse. You've got them to say there's a diagnosis in the DSM-5 about child abuse. And then you say, I notice you don't have a diagnosis of child abuse listed anywhere in your report. And that's yes or no. Do you have show me where that's listed? And I notice you don't even have it listed as a rule out. Well, no. What's a rule out diagnosis, doctor? That's when it's a possibility. Okay, so if it's possible that there's schizophrenia or bipolar disorder, We would rule out bipolar disorder. So that's one of the possibilities to be considered. So the fact that they did not put a diagnosis, even by rule out, even saying it was a possibility, they are then asserting for a fact that they have verified that there is no diagnosable pathology in the family, otherwise they would have told the court, that there is no child abuse in the family, otherwise they would have told the court, right? And so the fact that it's not there indicates that it's not present, not even by a rule out diagnosis. That's why over in clinical psychology, where I work, the I was told, I was instructed, taught to always put your diagnosis on all formal paperwork because otherwise you're asserting there is no diagnosable pathology present. And that's what I train my postdocs and interns to do. Put your diagnosis on all your formal paperwork. Uh, and so that's the diagnostic line, is to get them um, into saying first that they would disclose child psychological abuse or child abuse to the court, child psychological abuse, then that it's not present anywhere. Here's another um, rule of thumb with doctors in the medical world, with medical records. And we're doctors. The charts for your children are considered medical records. They're medical records. And documentation in medical records is very precise and taken very seriously. In all cases of dangerous pathology, that's suicide, homicide, and abuse, child abuse, spousal abuse, and elder abuse, we have to do a risk assessment. So if a patient comes in and says they're suicidal, we have to do a suicide risk assessment or make sure one gets conducted, get them to an ER or something, and chart it in the chart, in the medical record. If you didn't chart what you did, it didn't happen. That's the rule of thumb. If it's not charted, it didn't happen. So, for a suicide assessment, you sit down and say, conducted a suicide assessment, no family history, a suicide, no prior attempts, current plan using pills, no access to means, recent loss, and you just go down all the way to check. Suicide risk, mild, will increase sessions to every other week. Okay, so there's your kind of your chart note for a suicide assessment, a risk assessment. So now here we have possible child abuse. Possible child abuse by alleged towards the targeted parent, that there's something so awful about their parenting that the child doesn't want to be with them. Well, that's potential child abuse range. And potential psychological child abuse by the allied parent. That's the shared persecutory delusion and everything. And you can use the Walters and Friedlander quote for putting that into relevance, that there's possible child psychological abuse from the allied parent. So they should be doing a risk assessment for possible child abuse, each half of that. Is the targeted parent physically abusive, sexually abusive, neglectfully abusive, or psychologically abusive for the child? Do an assessment for that. Is this allied parent psychologically abusing the child, creating a false disorder, factitious disorder, imposed on a child, imposed on another, or through a shared persecutory delusion? So that should be assessed, a risk assessment for that. And so these forensic psychologists have obligations relative to the diagnosis of child abuse. So once you get them to say that it is possible that there's child abuse here, then you look at their report. That's when you go back and look at their report. And say, I notice you didn't put a child psychological or child abuse diagnosis anywhere. And even by rule out, where did you discuss your risk assessment for possible child abuse? They didn't. They didn't do a risk assessment. Um, so did you conduct a risk assessment for possible child abuse? Well, yeah, but where does it show that you did that? Where did you discuss that or discuss the results of your risk assessment? Okay, and don't argue with them. Just keep moving on. Um, and uh, for the um, diagnosis pathology, they are required to conduct a risk assessment. They didn't. The structure of forensic psychology reports is they basically record the interviews with everybody, then report on the recordings. They think it's being objective. No, it's just being lazy. It's basic. I could get a high school student to audio record interviews and then present the information. There's no processing of the information. It's just one person said, then this person said, and this person said. A lot of times they use a lot of quoting out of the transcripts that they produce from the audio recordings. Sometimes they quote them by paraphrasing. So they just basically paraphrase what everybody said. That's the entirety of 20 pages of reporting on the data. No processing. And then they do some testing, sometimes MMPI, some random tests that don't show very much. In fact, most of the tests don't show very much. And then they do some collateral interviews, telling about what various therapists or friends of the family have said. And then they just make up their conclusions and come up with some recommendations. They never apply any knowledge, they never apply anything. So they didn't actually do a risk assessment for possible child abuse. So that's going to get them in trouble. Because when you ask them, should they have done that? It's kind of, yeah. If there's possible child abuse here, they should do a risk assessment. And they're not because they think they're exempt. They're forensic psychologists. So that's the diagnosis line, is get them to first acknowledge that they do not diagnose pathology. Oh, I don't diagnose pathology. I'm a forensic psychologist. Then come back and say, would you tell the court about child abuse? Would you diagnose that? Would you identify child abuse if that was present? Well, yeah, I would identify. Where in your report did it discuss it? If they didn't chart it, if they didn't report it, it didn't happen. And don't argue with them. Just move them through that line. When you reach one of their most stressed points after these the ethical lines of questions, you'll want to come back to this diagnosis line and just ask them in a different context, in a different situation. When you're asking them about attachment pathology and family systems and possible delusional disorders, and when you're in that domain, ask them, could there possibly be child psychological abuse in the family? Because in that context, they're most likely to say, yes, that's a less risky answer than saying, no, there's no possibility there's child. Yes, it's possible there's child psychological abuse. That's going to be death to them because earlier in the questioning, you brought out that they didn't diagnose anything here, even by a rule out. They didn't say rule out possible child psychological abuse. Later on, they say there's possible child psychological. So you didn't really tell the court about any of this, did you? You didn't discuss it, and it's possible. You'll have them spinning all around. Switching over to the ethical lines. Now, for ethical lines, that's going to, again, shoot their anxiety right through the roof. And if you're coming off of the diagnostic questions now, they're really concerned because they didn't do a diagnosis and they're not used to, this is not forensic psychology domain that they're talking about. You've got them talking about clinical psychology domain. And if they ever say they are a forensic psychologist, I'm not, say, well, are you licensed as a forensic or are you licensed as a clinical? Okay. Was your degree in forensic psychology? Oh, no, your degree was in clinical psychology. Okay. And you're licensed as a clinical psychologist. And this is a subspecialty practice. You can get them to describe all that early on when they're all puffy and, yeah, I'm a forensic and no, I'm not a clinical and this is what it is. Very, very different. The central violation to the ethics code is Their failure to apply the established scientific and professional knowledge of the discipline as, as the bases for their professional judgments. The APA Ethics Code is mandatory, it is required, it says what it says. So I would have, whenever I introduce an ethics line, if it was up to me, it's not up to me, I'm not an attorney, but I would present them with the actual verbatim of this. Would you please read that? Do you agree with that standard? Do you follow that standard? If you want, ask them why the standard is important to apply. So standard 2.04, what you're going to do is run down each, maybe two or three probably, domains of knowledge that they should have applied. I'd start with family systems therapy, I'd move to attachment, and then I'd close it off with delusional thought disorders. And they don't have background in family systems, they didn't apply it. They don't have background in attachment, they didn't apply it. And they don't have background in delusional thought disorders, and they didn't apply. So they're kind of stuck on not applying any of the knowledge. And the reason they didn't apply any is because they don't know any. And that's the violation of standard 2.01, boundaries of competence. But that's a little in the weeds if you want to go there on the testimony. You'll find the boundaries of competence from their vita, that they don't have any background in training or experience in family systems, in attachment pathology, or in delusional thought disorders. But because they don't know the knowledge, they didn't apply the knowledge. So you stay focused on the failure of application. Now, when I do my analyses of forensic custody evaluations, I know it's going into court and people are going to fight about it and argue. So for standard 2.04, and the court likes evidence, they like documentation, and psychologists do as well. So I document the foundations for my opinion as to whether they complied with standard 2.04. And the way I did that, I'm doing that, is I constructed checklist of applied knowledge. And you can go up and get it from my consulting website on the attorney section. Checklist of applied knowledge. And it has 6 domains of knowledge: family systems, attachments, trauma, personality disorders, various things like that. And so it has 6 domains of relevant knowledge, each of them anchored by 5 specific constructs. So am I seeing any of these ideas from any of these domains of knowledge applied in the custody report? In addition, then it goes to diagnoses, just standards of practice and diagnoses. What was evident? Did they make a diagnosis? What symptoms were evident in their reporting? And then treatment and treatment planning. And they have goals and interventions and various things about treatment planning that should be included in a professional level report. So the checklist of applied knowledge looks at those 6 domains, and it is for standard 2.01. If they didn't apply any of the established knowledge, then the ethics code says what it says, and the report is absent the knowledge. Now, I'm a clinical psychologist, so I know what all the domains of knowledge are, and a lot. And I know what all those 5 terms or concepts mean, and you know how they might be discussed in different words, but not those words or those sorts of things. And so I can look through and say, no, none of these are present. Now, if you're an attorney or a parent, you're not qualified necessarily to know what a role reversal is, or a delusional thought disorder, but they are. Okay, and you can still go through and see if any of those terms were used, or if there was a discussion of attachment pathology or family systems. So if they used applied family systems therapy or in constructs and principles, you should see cross-generational coalition as a term used. You should see emotional cutoff as a term used, triangulation as a term used. Were any of these terms or related kind of constructs discussed? And if it's not, you can go down and do the checklist. You're not a psychologist, but you can do the checklist and you can give it to the psychologist and say, where did you discuss any of these issues? Now, before going into where did you discuss any of these issues, I'd walk them in gradually. Okay, so you start by saying you finish off with the diagnosis. Not quite finished, but you got them stressed out by that. Now you jump over to standard 2.04. Would you read this? Do you agree with this? Their anxiety's on the ceiling now. They realize you're going after their absence of knowledge. And so expose that. And you expose that by having them expose it. So again, going back to that early opening part, you would maybe just ask them about family systems. What is family systems therapy? Is that part of the established knowledge that would be applied? What does it mean? Triangulation mean? What does cross-generational coalition mean? Can you describe Mnuchin's diagram to me here? Would it be important to apply the established knowledge from family systems when assessing a family conflict? Would that be important? That's a yes or no question. No, that's not important to apply family systems constructs to assessing a family. That's going to be a hard sell if they answer that way. If they answer yes, it would be important. They're stuck because they didn't apply any. And so get them to back themselves into a corner. And they will know they're backing themselves into a corner. Assume they know information, and they will answer as if, because they have to kind of know it. So, and then back it up. Now, I notice you didn't discuss any cross-generational coalitions or triangulation or do anything like that. Okay, then before closing them off on that, switch a category and say, what about attachment here, doctor? Is it important to apply the knowledge of the attachment system when assessing attachment pathology? Yes. Okay. What is the attachment system? What types of insecure attachment are there? Okay. And so you expanded that. Why would it be important to apply this knowledge of attachment to? Would a child rejecting a parent, is that an attachment pathology? Yes, that's a yes or no question. Is that an attachment pathology? Yeah, that's a problem in the attachment breach. I notice you never discuss attachment in here. You go to Vita. I notice you don't have any training in attachment, or attachment pathology. You've just been doing these forensic psychology evaluations for 10 years. So you don't have any training in attachment pathology. Switch. Okay, what about thought disorders, doctor? And this is where I'd give him Walters and Friedlander quote and say, Walters and Friedlander say there might be a delusional thought disorder in the family, persecutory delusion. So would that be important? Is that the established knowledge that should be applied? Yeah. And did you? Where did you apply these sorts of things? So that's your standard 2.04 line of questions. Is you just go down basically the checklist of applied knowledge. I'd pick 3 attachment family systems, and delusional thought disorder should be enough to get them. And now switch over to, you can move to their Vita. Where on their Vita does it show any of this training? It doesn't. But then switch over to 9.01. Here's 9.01. It says that your opinions should be based on in your recommendations, reports, diagnostic or evaluative statements, including your forensic testimony today, should be based on information and techniques sufficient to substantiate your findings. Now, you didn't apply, before even getting there. Techniques, by the way, that one is the assessment for delusional thought disorders is a mental status exam of thought and perception. Nowhere was that included in the forensic psychology evaluation. And I would use the NCBI, National Institute of Health quote. That's just Google mental health, mental status exam, and it'll show up on the Google search, NCBI. And it basically, first paragraph says mental status exam of thought and perception is to diagnose thought disorder, delusions. And then the third paragraph says it's one of the most difficult ones to do, and it is. And it requires considerable experience, and it does. And that frequently the primary care physician will want a consult on a mental status exam of thought and perception, and that's also true. I'm trained in all of that, and that's what happens. We should be getting consults on delusional thought disorders because they don't know how to recognize them, and as a result, they are believing a shared persecutory delusion and are participating in the shared persecutory delusion because they believe it, because they misdiagnosed it, and as a result are participating in the child abuse and spousal abuse, which is phenomenally bad for a mental health professional. But they're practicing beyond the boundaries of their competence in assessing delusional thought disorders when they don't have any training or understanding of delusional thought disorders. So when in that whole line of questions about the delusion and persecutory possible, could there possibly be a persecutory delusion in this family, doctor? Is ask them what's the assessment for delusional thought disorders? They don't know. Give them the quote. Is it a mental status exam of thought and perception? First you expose, I don't know, or they kind of come up with something vague. Then you give them the mental status exam and they go, well, yeah, I guess it's that. And now you've exposed to the judge. They don't know what they're doing. And he said, did you conduct that? No, it says it's really hard. Do you have the training to do that? Where in your vita does it show you? Where in your report do you discuss a mental status exam of thought and perception and its findings? Okay, so when you get to 9.01, that's going to be that their opinions need to be based on information and techniques. And it's like legal statutes. You have the various clauses, information and techniques, both and. And information is the checklist of applied knowledge, family systems, delusional thought disorders, attachment pathology, standard 2.04. Information, techniques, mental status exam of thought and perception, sufficient to substantiate their findings. And when you get to 9.01, have them read it. Do they agree? Do they follow it? Do they follow it? And why is it important? Why would that be important? Now, on this one, though, I would look and say, I notice standard 9.01, bases of assessment, cites specifically standard 2.04, bases for scientific and professional judgments. Why is that, doctor? Explain that to me. Why would that standard specifically cite it? So standard 2.04 is really important to standard 9.01. So important they cite it. Is that what you're saying, Doc? Why would it be so important as a basis for your assessment to apply the established? Why would that be important, doctor? Get them to hang themselves on just the ethics code. And they already know you've gone through 2.04 and they didn't apply any of that. And so their risk assessment is just going off the charts at this point. They're exhausted. They realize they've said answers that got them in a lot of trouble. You can pop back to diagnosis again and say, is it possible there's child abuse in this family? At this point, they've gone through the possible attachment pathology. They realized that they didn't apply any of that, and they didn't apply any of the delusional thought disorders. They're going to try to say, I'm just custody. Keep them on yes or no questions and expose it. Then, is it possible there's child abuse in this family? Psychology. It's possible. Yeah, it's possible. They just said they don't have a rule-out diagnosis on it. Okay, so they're in trouble because they didn't tell the court it's possible. They didn't discuss any of that. At this point, again, I'm not an attorney, but my question is it possible that there's a child psychological abuse? Now, you didn't mention, you didn't discuss any of that with the court. Would you recommend, it's not my role, I'm a forensic psychologist, I do custody, and I don't, would you then recommend, is one of you, that an additional diagnostic risk assessment for possible child abuse be conducted, doctor? That's a death question. Would you recommend then, doctor, that an additional assessment for a risk assessment for possible child abuse be conducted, doctor? If they're only answer, that's a yes, no. So if they say no, okay, they're asserting that they conducted one and that there's no child abuse and that there's no, and so they're going to be way out on a limb on that one. The most likely, the least dangerous answer that they think they can give is yes, that there should be an additional clinical diagnostic risk assessment for possible child abuse. Whew, I'm off the hook. I'm a forensic psychologist. No, you're not. If there's possible child abuse, you had an obligation to conduct the risk assessment or see that it was conducted. Doctor, where in your recommendations do you recommend a clinical diagnostic risk assessment for possible child abuse? They failed in their duty to protect. They failed in their duty to protect, and that's a legally obligating duty. We have duty of care and duty to protect. They failed like a suicide assessment. If the patient says they're suicide, they failed to conduct a suicide assessment. So you're saying that even after your 6 to 9 month evaluation that cost us, $20,000-$30,000, we still need another assessment because your assessment was inadequate in the evaluation of possible child abuse. Do you think that's relevant to the court, child abuse and possible child abuse? But you didn't answer that question, did you, doctor? So we still need to get another assessment before we know what to do about this, because you didn't identify what the problem was, did you, doctor? Oh, identify. Did you diagnose what the pathology was? I don't see a diagnosis. So you didn't really even identify what the problem was. And because of that, we need to go get another assessment to identify what the problem is so we know how to fix it, because your assessment is entirely inadequate. So that's sort of my approach to coming at and exposing their vulnerability. Now, for me, just sort of in closing on the question line, I would have them go back to standard 2.04 and 9.01 and read them again. 2.04. So would you read that again for me, doctor? In this matter, in your evaluation, do you believe you met your ethical requirements under standard 2.04? I just want them on the record for that. Yes or no? Do you feel you met your standard, your requirements for the application of the established scientific and professional knowledge? They're going to have to say yes. Yes, I met my standard. But then they're obviously lying because you've taken them through and they haven't applied any knowledge. And it's obvious to the judge. The judge can read their report. They didn't fail discussion of family systems, discussion of attachment, discussion of delusional thought disorders. Nothing. Okay. And then we have them read 9.01 as my closer, which would be, read it again. Do you believe that your recommendations, as contained in your report and your evaluative statements, including your forensic testimony here today, has been based or is based on information and techniques sufficient to substantiate your findings? No, it's not, because they just said we needed a new assessment. So no, it's not, because we need a diagnostic risk assessment for possible child abuse before we know what to do to fix things. If there's one parent's abusing the child, that becomes kind of important to know. So that's my approach or my recommended approach to assessing mental health testimony. forensic psychology testimony. Now, sometimes forensic psychologists, I've seen a few reports where they will make a diagnosis. It's typically a misdiagnosis. Um, but when you get there, you can talk about possible misdiagnosis. So if they diagnosed adjustment disorder, and you say, "I'm not seeing that you added a V code for the child abuse, so you don't think there's any child abuse here. You didn't even put it as a rule out. You don't think there's possible child abuse as part of this adjustment disorder that you've identified, or depression, or anxiety, or whatever the case." And treatment-related reports should always have diagnoses on them and have a whole bunch of other requirements, kind of. Um, for a treatment report, as if I'm supervising a report coming through to me, and the postdoc trainee says the diagnosis is ADHD, attention deficit hyperactivity disorder. Well, there's 9 symptoms of hyperactivity, 9 symptoms of inattention. They have to meet 6 of the 9 to get the diagnosis of either hyperactivity or inattentive ADHD, 6 of 9. So I expect in that report to see which 6 symptoms they met for their ADHD diagnosis at the end. For major depression, there's 8 symptoms of a depressive episode. The person has to meet 5 of them to get a diagnosis of major depression. If they meet 4, that doesn't mean they're not depressed. That person's depressed, but they don't meet criteria for the diagnosis. So when a diagnosis is made, you want to see the symptoms that it was based on. And diagnosis is not an opinion. Okay? That's important to understand. Doctors are kind of like judges. We're kind of parallel each in our systems, and we do this kind of the same thing. The judges in their legal system apply the legal statutes to the evidence. We apply our diagnostic criteria to the symptom evidence. Okay, so it's the same sort of thing. There's no question about what the legal statutes wording says. There's no question about what the diagnostic criteria say. There's no question about what the evidence is. It might be a little vague in somewhere, but we got the evidence, we got the symptom evidence. The only place for an opinion is, does this particular symptom meet this criteria of the diagnosis? Does this particular evidence meet this legal wording of the statute? There might be an opinion there, and that's where you get appeals. In the legal system, you get an appeal whether or not that was properly applied or whatever. And over in the healthcare system, you get a second opinion. If you're unsure whether this symptom meets that criteria, you get somebody else and you get a second opinion on it. That's what we do as doctors. And that's our appellate system over here. So the treatment providers, just the other element of the treatment providers that you may run into are the individual therapists, but typically they're put aside and they're not brought in for testimony because they believe they have some sort of protected status, confidentiality, safe harbor, I think is what they call it. And that's not true. These children are downloaded by the allied parent after each session. They know what to tell the individual therapist. Occasionally, the individual therapists will introduce reports to the court, typically saying the child's not ready yet, and they'll use that word, not ready. Whenever you hear the child's not ready, that's the pathology talking in the mental health person. No, the child's totally ready to be loved. No child is like, I'm not ready to be loved. No. The child's ready to be loved. They're just buying into the delusion, the persecutory delusion, because they want to be helpers and there's countertransfer and stuff. So if the individual therapist, child therapist, gets some sort of report into the courts, then they're going to have to back it up with testimony. And that's where you come in again with, did you do a proper risk assessment for possible child abuse? Could this be a possible delusional disorder? Did you do an assessment for a delusional disorder? No, they didn't. And so my cuckoo clock just went off, so I'm going to be heading out of here. But here's an important idea regarding this pathology, and it kills me, it drives me crazy, is with this shared delusional pathology. No other pathology is shared. You don't have shared autism, you don't have shared ADHD. You do have shared delusions. And with this particular type of pathology, a shared persecutory delusion, if you believe the shared delusion, you become part of the shared delusion. You become part of the pathology. When that pathology is child abuse, you become part of the child abuse. You become a child abuser. So the mental health people who actually have duty to protect obligations are actually participating in the child abuse because of their ignorance and incompetence, practice beyond the boundaries of their competence. They don't know the knowledge that should be applied. And as a result, they believe the shared delusion and are becoming part of the pathology. The individual child therapists are the most egregious violators of this because they don't do a proper assessment and don't have the necessary knowledge. And so, in their individual sessions, they are believing the delusion and supporting it and creating it. So, they're a difficult group, and I'll have separate talks about the individual therapists. There's no need for an individual therapist with this pathology. No, 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 no. There's nothing wrong with the child. The pathology's in the family, not the child in this case. So there's just a massive misdiagnosis over here. So with that, good luck to the parents in getting your kids back, and we'll keep working at it. All right, bye bye.